In this video, I'm going to be looking at the separation of powers and judicial independence. Now this is quite a hefty topic, so this video is going to be a bit longer than usual, and you might need to watch it a couple times to fully understand the concepts here. First, looking at the idea of the separation of powers. Montesquieu was a famous French political philosopher and judge who came up with the theory of separation of powers. He said that there are three arms to a country and they must be kept separate to avoid despotism, and that's the exercise of absolute power in a cruel and oppressive way. The three arms include the executive, which is the government, who make policy, the legislative, who are parliament and create law, and the judicial, who are the courts and they enforce the law. The separation of powers requires people not to be members more than one arm. The UK doesn't have full separation, as the Lord Chancellor is involved in all three arms. There's also an overlap between the executive and legislative, as ministers who are part of the government can also sit in Parliament. Judicial independence is an idea that links directly to the separation of powers. This is the idea that the judiciary should be kept separate from other sections of the government, so they'll be able to freely exercise their role without interference. Now I'm going to look at some rules that promote judicial independence. So it's very hard to sack a High Court judge, as you need Parliament to agree. It's fairly hard to sack other judges, as the Lord Chief Justice and Lord Chancellor have to agree. Judges are controlled by the Judicial Conduct Investigation Office. You can't sue a judge, otherwise people would sue after any verdict, but they're still held accountable through appeals. Judges' pay is not debated by Parliament, and judges cannot become MPs, as this would interfere with the lawmaking process. Now I'm going to look at some cases which directly relate to this idea of judicial independence, the first one of which is Dimes v Grand Junction Canal. Looking at the facts of this case, a judge was making a decision in a dispute involving a canal company. He was a shareholder in the company. There was a conflict of interest there, so the decision was void and a retrial ordered. As he was a shareholder in the company, there was a clear bias there, and he might rule one way or the other. The key idea from this case and the next one that I'm about to talk about is that judges cannot have personal biases that interfere with the outcome of the case, and this is a key role in ensuring judicial independence. Looking at the next case of Pinochet. Spain issued an arrest warrant for breach of human rights for Chilean dictator Pinochet. He went to London in 1998 where he was arrested. Spain issued an extradition request. The Supreme Court decided on appeal that he could be sent to Spain for trial. Justice Hoffman, a judge on the case, was a director of a human rights organisation. This was a conflict of interest, so the decision was void. As Justice Hoffman was so involved in human rights, he could be more likely to have ruled against Pinochet, as he had breached human rights. I'm now going to look at the advantages of judicial independence. An independent judiciary is essential in protecting the liberty of the individual from abuse of executive power. An independent judiciary is vital in a democracy. The government cannot force a judge to resign if the judge makes a decision that the government disagrees with. This is good, as judges can carry out decisions without fear of punishment. A final advantage is that judicial independence is that judges are impartial in their decisions. In the next video, I'm going to be looking at judicial review, which is an idea that links directly on from the ideas I've looked at in this video. Here's what a question might look like on this topic. Hopefully this video is helpful. Have a nice day.